What's good? What's going on, guys? Welcome back to the channel. Freeland Audits here, and this guy right here, Sofo Money Coat Mill 5296. Guys, this is in reference to a video right here that where I had performed an audit and found illegal signage. Um, you know, the signs that were in there were citing courtroom rule 22, which were removed in a follow-up video, which I will show you guys at the end. Uh, I actually believe I had posted a link or pinned a comment or something about the follow-up video. Anyways, the guy tries to combat me with unconstitutional except for the 10th Amendment. The judge can actually declare cameras off limits for the entire courthouse, which was entirely wrong. Um, you know, he said got bored and stopped watching, but I guess you are being rude, not them. Security cameras aren't used for personal gain. 13 minutes in and everything you've said is wrong. I doubt you get smarter as it continues. LOL. So to him, at first kind of the little troll thing, but he wanted to. I said, you really need to learn case laws around the 10th because you were incorrect. The judge does not have jurisdiction over the courthouse. They only have jurisdiction over their courtroom. Nice of you to show your intelligence. Maybe you need to learn the laws and stop licking, not locking, licking the governmental boots. And and you are incorrect because about the 10th Amendment, it has nothing to do with the judges. You're way off. And he was way off. The 10th Amendment gives states their powers to make their own laws and enforce them. Now, we continue to go on for a bit. Back and forth, back and forth, back and forth. I told him what state I lived in. He said, "What state were you in?" I'll just quickly look it up and prove you wrong when I get home. LOL. I said Georgia, and you can't prove me wrong. And we're still going back and forth, back and forth, back and forth. Right here. This is one he had just sent today. 10th Amendment gives states right to make their own rules, and the 10th Amendment is in the Constitution. The last I checked, yes, it is. But again, the law that we are discussing here is actually, hold on, let me go back. Not there. Um, is actually the OCGA 15-1-10, aka Rule 22, which is here. Not that one. Anyways, where did I have it? I had opened it up somewhere. Yeah, right here. New rule approved for recording devices in courtroom. And I'm just going to make this a little bigger. That way we can all see it. The Supreme Court of Georgia has approved a revised rule for the Superior Courts of Georgia governing the use of electronic devices in courtrooms and the recording of judicial proceedings. The new version will take effect on Monday the 1st, or on May the 1st, 2018. Rule 22 of the Uniform Court Rules was issued in 1997 and has not been updated since then. The new version reflects the dramatic changes in technology and news media over the past 2 decades, and particularly the fact that most Georgians now have smartphones and other electronic devices that can be used as still cameras, which is taking a photo, video cameras, and audio recorders. The rule addresses the use of such devices for recordings and non recording purposes by lawyers and their employees, parties in court cases, jurors, witnesses, and media representatives and other spectators. As the new rule underscores at the outset, open courtrooms are an indispensable element of an effective and respected judicial system. The rule recognizes that a balance must be struck in the use of recording devices in courtrooms. It is the policy of Georgia's court to promote access to and understanding of court proceedings, not only by the participants in them, but also by the general public and by news media who will report. Let me see. So basically, what it is this here. Think isn't that the same thing? Yeah. So it's the same thing. Forgot I already had it open. It is ordered that this is the Honorable Supreme Court met pursuant to adjournment. The following order was passed. It is ordered that Uniform Superior Court Rule 22, which relates to the use of recording devices in courtrooms and proceedings of judicial proceedings by representatives of the news media and other persons, be amended. The amended Rule 22, which is the product of several years of study and discussion by the Council of the Superior Court Judges, this court, and numerous organizations that provided written and oral comments on proposed rule drafts, replaces the existing Rule 22 in its entirety. The amended rule continues to implement OCGA 15-1-10, but is updated to reflect developments over the last 2 decades in recording technology in the news media, and most significantly in recording devices, namely smartphones and other mobile computers with recording capabilities that today are routinely carried and used by most people. The amended Rule 22 takes effect on May 1st, 2018. So, except otherwise required by law, this rule governs the use of recording devices or the use of devices to record sounds or images in a courtroom or comports with the standard provided in OCGA 15-1-10. Regarding the use, dot one also, regarding the use of devices to record judicial proceedings. Now, basically, what this rule says, and you guys can go and look it up. As you see, it's a lot. I'm not going to read the whole thing. Here's where you can fill out to get permission to record. But basically, what the rule says is that there's to be the use of no recording devices, which you'll see right here. All parties and spectators shall turn the power off to any recording device while present in a courtroom unless the judge allows orally or in writing the use of recording devices in the courtroom for purposes other than recording sounds and images, which the judge may freely do when he or she believes such use would. Now, let's go ahead and look up my favorite thing, First Amendment rights. All right, what the First Amendment states. The First Amendment provides that Congress make no law respecting an establishment of religion or prohibiting its free exercise. It protects freedom of speech, the press, which is freedom of the speech, freedom of the press, freedom to assemble, and the right to petition the government for a redress of grievances. That is the First Amendment. That is what this guy is arguing about. The First Amendment is a constitutional right. Yes. Now, let's scroll on down. The 10th Amendment assigns all powers not delegated to the United States or prohibited to the states, to either the states or to the people. Now we're just going to come back over here. And instead of the first, we're going to look up the 10th Amendment rights. The power is not delegated to the United States by the Constitution, blah, blah, blah. I just read all that. Here we go. Congress.gov. I love this website. And then we go to explained. Now, this is where things get tricky because every single one of these is an amendment to the 10th Amendment. It's like a subsection of the 10th Amendment explaining rights reserved to the states and the people. Because the 10th Amendment concerns the relationship between the federal government's powers and those powers reserved to the states, it is sometimes invoked implicitly or explicitly in cases exploring the limits of in Congress's various enumerated powers. These decisions are primarily addressed elsewhere in the Constitution and noted under the particular enumerated federal power issue. The key issue in the 10th Amendment doctrine, as such, is whether the amendment imposes affirmative limitations on federal power, which it doesn't really restrict them too much because, I mean, the federal is the highest law, right? So, like, the FBI can come in and decide to intercede if they see fit in a case that your local city police department or county sheriff's office or uh, um, state agency is working on. The Supreme Court's jurisprudence on these questions has not followed a straight line. At times, the court has stated that the 10th Amendment lacks substantive constitutional content and does not operate as a limitation upon the powers expressed or implied or delegated to the national government. Um, Basically, let's just go ahead and make this real simple for this guy. In Georgia, there is no law that restricts you from recording in a courthouse. A courthouse is a public building, which would be, ready? I'm about to look it up. Smith v. Cummings. Again, 11th Circuit, which is really good. All right. Okay. James and Barbara Smith filed suit against the city of Cumming, Georgia, coincidentally enough, and its police chief, Chief Singletary, pursuant to 42 USC 1983, alleging that the city police had harassed the Smiths, including a claim that Mr. Smith had been prevented from videotaping police actions in violation of Smith's First Amendment rights. They appeal from summary judgment granted to the city and Singletary and from the denial of the Smiths' motion to amend their complaint so as to name another city police chief, Ralph Buck Jones, a defendant in the place of a defendant originally identified as John Doe. We affirm. As to the First Amendment claim under Section 1983, we agree with the Smiths. They had a First Amendment right subject to reasonable time, manner, and place restrictions, guys. This is an important part. As to the First Amendment claim under Section 1983, we agree with the Smiths that they had a First Amendment right subject to reasonable time, place, manner, and place restrictions to photograph or videotape police conduct. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest, which is saying going into a courthouse and recording is well within the rights. Right there. They ruled on this. And this was done in 2000. It was filed in 2000. It was decided in 2000. I mean, literally the day it was filed, it was decided. So, um, listen, my guy, I'm just gonna call you Sofo. Um, Dude, do your research. I've said it several times. Do your research, man. Do your research. I urge you to research the Constitution and federal case laws, which, believe it or not, the whole recording in public thing, that is a federal case law, man. It is. It went to the Supreme Court. It was ruled on. So stop arguing because literally everything I was telling you is true. And like I told you, I can prove it. I did your research for you because you didn't want to. This is an educational piece. This is not a debate about who's right and who's wrong. It's education. It now, if you come to me and you ask me to prove it, I will. And this is for anyone else on my channel too. You know, if you guys actually skip through to it, you'll see exactly what I was saying. I'm not gonna drag this out much longer, guys. Um, I just wanted to do this so everyone is aware that what I am doing is right. And actually, if you doubt that, you can follow We the People University here on YouTube, and he will help you. He covers stuff like this. He's done it several times. Um, he was the first place where I heard about Smith v. Cumming. So I'm not breaking a law. And is it annoying to have people come up to you and ask you questions about a sign that is deemed unconstitutional? Sure. Should the sign be there to begin with? No. Am I well within my rights to address that? Under the First Amendment, yeah, I am. I can redress my grievances with my government. And that's exactly what I was doing. The signs are down anyways, so um, let me actually where was that? Where was that? Where was that? Where was that? That pinned comment. Uh right here. So we're just gonna come up here. We're gonna go to my channel. And as you guys see, I really don't have a whole lot of videos, but I have this. This video right here. This video says it all. I mean, I went back and the signs were down. The lady was professional. Nothing bad was happening. So if I was actually breaking the law and I was doing something wrong and I'm going to go to jail, why were the signs removed? Okay? So it's not a point of arguing. It's a matter of educating people on what their rights are because just like you, Sofo, nobody knows. Nobody is aware of what their rights are. All right, guys, look, thank you for watching the video. I appreciate it. Um, please, please, please go ahead, smash that like button, subscribe to the channel if you haven't already. And as soon as school starts back, I'm going to be posting more videos again. All right, guys, Freeland Audit out.